In this lecture, we shall discuss the reforms introduced by the Land Act of 2020, Act 1036. The reforms introduced by the Land Act of 2020, Act 1036. The reforms introduced by the Land Act of 2020, Act 1036. This law was assented to by the President of the Republic of Ghana on the 23rd of December 2020. On the 23rd of December 2020. And if you look at the long title of the Act, we are told that it is an act to revise, to harmonize and consolidate the laws on land, and to ensure sustainable land administration and management, effective and to ensure efficient land tenure, and to provide for related matters. So this act has as its purpose the revision, harmonization, and consolidation of the laws that relate to land in Ghana. And so it is important to understand all the provisions in this act because its purpose is to revise, harmonize, and consolidate the laws on land in Ghana. Now, it is important at this point to mention that this lecture is part of a series of lectures that are available on the Digital Law Village channel on YouTube. And so we will only discuss the reforms that have been introduced in this particular act. But in terms of the details about the substantive law principles, it will be helpful to refer to the other videos and lectures that have been given and published on the Digital Law Village channel that are available on the YouTube channel. It will be helpful that you subscribe. Just look at the YouTube channel and then subscribe and turn on the notifications so that for all other subsequent videos that will be posted, you receive prompt notifications as and when videos are posted. But for our present purposes, we are looking at the discussion on the reforms that have been introduced by the Land Act of 2020, Act 1036. Act 1036. Now, as you see from the long title, it is an act to revise and consolidate and harmonize the laws that relate to land in Ghana. And one way it achieves that is that if you look at section 282 of the Land Act of 2020, Act 1036, you will see a series of enactments that have all been repealed. Because you see, what the law did was to repeal all those enactments and then consolidate all of them into a single legislation, which is the Land Act of 2020, Act 1036. And so if you look at section 282, it reads as follows, and I quote, "The following enactments are repealed. A. Land Development Protection of Purchasers Act, 1960, Act 2. B. Farmlands Protection Act, 1962, Act 107. C. Land Registry Act, 1962, Act 122. D. Administration of Lands Act, 1962, Act 123. E. State Lands Act, 1962, Act 125. F. Section 11 of the Survey Act, 1962, Act 127. G. Lands Miscellaneous Provisions Act, 1963, Act 161. H. Public Conveyancing Act, 1965, Act 302. I. Rent Stabilization Act, Repeal Decree 1966, NLCD 49. J. Rent Stabilization Amendment Act, 1966 NLCD 103. K. Conveyancing Act 1973 NLCD 175. L. Public Lands Protection Act 1974 NLCD 240. And M. Land Title Registration Act 1986 PNDC Law 152. All of these legislations have all been repealed. They have all been repealed. They have all been repealed. All these legislations that relate to land, all these legislations, Land Registry Act, Administration of Lands Act, State Lands Act, Land Act, in fact, they have all been repealed. And that is why we are told in the long title of the Land Act of 2020 that it is an act to revise, to harmonize and consolidate the laws that relate to land in Ghana. So that previously, if you want to get the full complement of laws that relate to land in Ghana, you must look at all these laws from A, B, C, D, E, F, G, H, I, J, K, L, and M. All of these relate to the land in Ghana. But now, we have repealed all of these, we have revised them, we have consolidated them into a single act, the Land Act of 2020 Act 1036. So what are the reforms that have been introduced in this act? It means when you take this act, you have the full complement, or at least 90 or 95% of a lot of the laws that relates to land in Ghana. So what are the notable reforms that have been introduced by this Land Act of 2020, Act 1036? The first notable reform we shall see is in Section 1 of the Land Act of 2020, Act 1036. In Section 1 of the Land Act of 2020, Act 1036. You see, what Section 1 does is that it brings clarity on the structure of the interest in land that we have in Ghana presently. It tells us that these are the respective interests that a person can hold in land in Ghana. But in order for you to appreciate the full import of how this amounts to a very notable reform, it is important that we refer to what was in existence before this came into force. So let us take a look at the Land Title Registration Law 1985 PNDC Law 152, which was in existence before the coming into force of the Land Act of 2020 Act 1036. Remember, it has now been repealed, but that was the law that was in existence before. And let us see, because this Section 19 had an interesting provision that would give a deeper insight to the now Section 1 of our Land Act of 2020. So Section 19 of the Land Title Registration Law 1985 PNDC Law 152 says as follows, and I quote, "A person shall be registered as proprietor of land if, in relation to that land, that person, A, is the allodial owner. That is to say, that person holds it under customary law where that person is not under a restriction on the rights of user or obligations in consequence of that holding, other than restriction or an obligation imposed by the law of the Republic generally. B, that person holds a customary freehold. That is to say, that person holds the right of user, subject only to the restrictions or obligations imposed on a subject of a stool or a member of a family who has taken possession of land which the stool or family is the allodial owner without consideration on payment of a nominal consideration in the exercise of a right under customary law to the free use of that land. C, holds the land for an estate of freehold vested in possession or an estate or interest less than freehold, according to the rules generally known as the rules of the common law. And then D, holds a leasehold interest. That is to say, that person holds an interest under a lease for a term of years, of which more than 2 years are unexpired. And E, that person holds a lesser interest in land. That is to say, holds an interest in land by virtue of a contractual or sharecropping or any other customary tenancy arrangements. Now, these are the different categories of registrable interest that were mentioned under Section 19 of the Land Title Registration Law 1985, which was in existence before the coming into force of this Land Act. It makes mention of allodial interests. It makes mention of customary law freehold. Then it makes mention of a land for an estate of freehold. Then it makes mention of leasehold interests. Then it makes mention of lesser interests. So I want you to bear in mind these different interests that were mentioned in this old law, that is Section 19 of the Land Title Registration Law 1985, PNC Law 152, so that you can get a better insight and appreciate the different categories of interest that are now mentioned under Section 1 of Act 1036. So, Section 1 of Act 1036, it says the following are the interests in land: A, allodial title; B, common law freehold; C, customary law freehold; D, usufructuary interests; E, leasehold interests; then F, customary tenancies. Customary tenancies. Customary tenancies. So you realize that at this point, there is a distinction between the usufructuary interests and the customary law freehold. Because when we read what we have under Section 19 of the Land Title Registration Law, we only saw the mention of customary law freehold. And so some text writers used to confuse and treat as synonymous the customary law freehold and the usufructuary interest. But now we see under the Land Act of 2020 Act 1036 that there is a distinction between the customary law freehold and then the usufructuary interest. That is one cardinal distinction that you should note. In fact, the lawmaker has now given us the distinction between a common law freehold, a customary law freehold, and then a usufructuary interest. So that if there was any doubt about whether the customary law freehold is the same as the usufructuary interest, now you cannot use them interchangeably, because we have distinguished the customary law freehold from the usufructuary interest. From the usufructuary interest. And then one remarkable act of the lawmaker is that in order not to leave it in any further doubt about what is customary law freehold, what is usufructuary interest, what is common law freehold, the lawmaker has devoted different sections to explain and define what we mean by common law freehold, what we mean by customary law freehold, and what we mean by usufructuary interest. And so, if you look at Section 3 of the Land Act of 2020 Act 1036, you will see the definition of the customary law freehold over there. Customary law freehold, that it's an interest in land that arises from a transaction under the customary law. So you see that there's a definition given to the customary law freehold, so that we will save ourselves from the trouble of people having to confuse the definition of customary law freehold with common law freehold. Again, the definition for common law freehold, we see that one under Section 4. And then there's a different section, Section 5, for the definition for usufructuary interests. Usufructuary interest. And so, one reform that is very laudable is that this section 1 has brought clarity on the different categories of interests that can be held in land in Ghana. So when you read the section 3, you read the section 4 and section 5, you get the full import of the definitions for these respective kinds of interests. Now, the next reform we shall discuss is the prohibition of the creation of freehold interests. Prohibition of the creation of freehold interests. That will be our second reform that we shall discuss. And on this, it is important for us to refer to Article 267 Clause 1 of the 1992 Constitution of Ghana. Article 267 Clause 1 of the 1992 Constitution of Ghana. It reads as follows, and I quote, "All stool lands in Ghana shall vest in the appropriate stool on behalf of and in trust for the subjects of the stool in accordance with customary law and usage. All stool lands in Ghana shall vest in the appropriate stool on behalf of and in trust for the subjects of the stool in accordance with customary law and usage." So you see, what Article 267 Clause 1 of the 1992 Constitution does is that it has created a trusteeship concept for stool lands. The stool lands must vest in the appropriate stools, that the stool would only hold it on behalf of and in trust for the subjects. It means that if you are occupying the stool, the land doesn't belong to you. You are just a trustee to hold the land in trust for the subjects in accordance with the relevant customary law and usage. So Article 267 Clause 1 creates a trusteeship concept in relation to stool land. Now, because of this trusteeship concept, Article 267 Clause 5 says that because you are just a trustee, then you cannot create a freehold interest in the stool land. Because think about it, if you are a trustee and as the occupant of the stool, you are supposed to be holding the land for yourself and then in trust for the subjects of the stool. How on earth should it be wise for you to create a freehold and give the land to, let's say, a stranger who can hold it forever? What will happen if the people who are born 50 years to come, what land will they have? So if we say that it shall vest in the appropriate stool on behalf of and in trust for the subject of the stool, in accordance with the relevant customary law and usage, Article 267 Clause 5 goes ahead to prohibit the creation of freehold interest in stool land. Emphasis on in stool land. Stool land. This is what Article 267 Clause 5 of the 1992 Constitution reads, and I quote, "Subject to the provisions of this Constitution, no interest in or right over any stool land in Ghana shall be created which vest in any person or body of persons a freehold interest howsoever described." I'll take the quote again. Subject to the provisions of this Constitution, no interest in or right over any stool land in Ghana shall be created which vest in any person or body of persons a freehold interest howsoever described. Now, before the coming into force of this Land Act, the view that had been usually paraded in several circles was that in Ghana, you cannot create a freehold interest in any land at all. But if you look at the wording of Article 267 Clause 5, it only created the trusteeship concept for stool lands, and therefore the prohibition in creating freehold interest was only in relation to stool lands, meaning that the Constitution in its letter did not prohibit the creation of freehold interest in family land. And so that is why if you look at the definition of stool land under Article 295 of the 1992 Constitution, it doesn't define stool land to include family land. look at the definition of stool land under Article 295 of the 1992 Constitution. It reads as follows, and I quote: stool land includes any land or interest in or right over any land controlled by a stool or skin, the head of a particular community, or the captain of a company for the benefit for the subjects of that stool or the members of that community or company. So look at it, that when it comes to stool land, the definition does not include family land. It talks about land held by a stool or skin or the head of a particular community. Nowhere do we see any mention of family land. And so there was this case of Republic versus Regional Lands Officer who expert the Cluj, because at the time when people create freehold interest and sometimes they want to register a lands commission, the Lands Commission will rely on Article 267 Clause 5 and say that they will not register the interest. And they'll be saying that in Ghana, there's a prohibition of the creation of freehold interest. But what was being missing was that Article 267 Clause 5 only prohibited the creation of freehold interest in stool land. So in this case of Republic versus Regional Lands Officer, who, as per the Cluj, reported in 1997-98, One Ghana Law Report at page 1028. The applicant in this case who applied for the mandamus, he had sought to register a family land as a freehold, and then the Lands Commission was refusing. So he brought an application for mandamus against the Regional Lands Officer who, seeking for an order to compel them to register his freehold interest in stool land. And the basis of his argument was that the Constitution only prohibits the creation of freehold interest in stool land, and that it didn't prohibit the creation of freehold interest in family land. So in Republic versus Regional Lands Officer, who, as per the Cluj, the application was for an order of mandamus directed against the Regional Lands Officer to compel him to register the land document of the applicant, because according to the applicant, his land is a family land, and therefore, according to Article 267 Clause 5, the prohibition for the creation of freehold was only in relation to stool land. And as since his land was family land, they ought to register the land for him. The court agreed with him. The court agreed and awarded the order of mandamus to compel the Regional Lands Officer to register the freehold interest, because according to the court, the prohibition under Article 267 Clause 5 was only in relation to stool land, and it didn't relate to family land. And so in this case of Republic versus Regional Lands Officer, who, ex parte Cluj, reported in 1997-98, One Ghana Law Report at page 1028, the court granted the order of mandamus to compel the registration of the freehold interests in family land. But there's a reform now under the Land Act of 2020 at 1036. When you look at Section 9, Subsection 1 of the Land Act of 2020, it has brought about an interesting innovation under the Land Act. You remember the trusteeship concept that we saw in relation to stool lands under Article 267, where we realized that under Article 267 Clause 1, the stool lands were vested in the appropriate stool on behalf of and in trust for the subjects. Now, that trusteeship concept, we have replicated the trusteeship concept and brought it also for family land. That is an interesting innovation and reform introduced by the Land Act of 2020 at 1036. If you read Section 9, Subsection 1 of the Land Act of 2020 at 1036, it reads as follows, and I quote: a stool or skin or clan or family land shall vest in their property stool or skin or clan or family. Again, a stool or skin or clan or family land shall vest in their property stool or skin or clan or family on behalf of and in trust for the subject of the stool or skin or members of a clan or family in accordance with customary law and usage. So what have we seen over here? That trusteeship concept that we saw under Article 267 Clause 1, that was in relation to stool land. The trusteeship concept has been lifted, and now we've added family land to the trusteeship concept, so that today, family land shall vest in the proper family on behalf of the subject of that family in accordance with relevant customary law and usage. So, now that we have brought the trusteeship concept to family land, the lawmaker now goes ahead to prohibit the creation of freehold interest in family land as well. Now, let us look at Section 9, Subsection 2 of the Land Act of 2020, Act 1036. Act 1036. This is what it says, and then I quote: a person shall not create an interest in or right over any stool or skin or clan or family land which vests in that person, another person, or body of persons a freehold interest in that land, howsoever described. Now let us compare this to what we had under Article 267 Clause 5. Article 267 Clause 5 only prohibits the creation of freehold interest in stool land. But this new Section 9, Subsection 2 of the Land Act of 2020, Act 1036, it is prohibiting the creation of freehold interest in family land as well. Look at the wording. A person shall not create an interest in or right over any stool or skin or plant or family land. Family land is mentioned there, which vests in that person, another person, or body of persons a freehold interest in land, howsoever described. Meaning that effective from this Land Act of 2020, Act 1036, the creation of freehold interest in family land has also been prohibited. The creation of freehold interest in family land has been prohibited. In other words, that case we saw, that is the Republic versus Regional Lands Officer who ex parte Kluge. You remember that case? That was the case in which the court held that the prohibition in the Constitution didn't prohibit the creation of freehold interest in family land. So that case, the court granted an order of mandamus to compel the Regional Lands Officer who to register a freehold interest in land. You remember that case? Republic versus Regional Lands Officer who ex parte Kluge. Now, that case will not be bad law. That case will not be dead law because under Section 9, Subsection 2, we are told that you can also not create a freehold interest in family land, howsoever described. Meaning that the case of Republic versus Regional Lands Officer who ex parte Kluge will not be bad law, because now we have prohibited the creation of freehold interest in family land. But let me just add a word of caution. It is important that you take note of this caution. And this caution I'm about to give springs from Section 9, Subsection 3 of the Land Act of 2020, Act 1036. You see, even though the Land Act is prohibiting the creation of freehold interest in family land, you remember when we look at Section 1 of the Land Act, we listed some categories of interests that can be held in land in Ghana. And one was customary law freehold. The other was usufructuary interest. You remember those provisions, right? Now, when you look at the definition of usufructuary interest under Section 5, you are told that it is the right that is inherent to a subject of a stool or skin or family member to move into any land which is terra nullius, or an unoccupied portion of land, reduce it into his possession and cultivate it, he will acquire the usufructuary interest. Meaning that under Section 5, a subject has an inherent right to uncultivated land, to cultivate it and then reduce it into his possession, then he acquires the usufructuary interest. So even though we are prohibiting the creation of freehold interest in family land under Section 9 of Section 2, the lawmaker was very fast in adding that subsection 2 does not take away the inherent right of a subject of a stool or skin or member of a family to the usufructuary interest in a vacant portion of the stool or skin or clan or family land. What does this even mean? It means that even though we have prohibited the creation of freehold interest in stool land and in family land now, that prohibition does not apply in relation to the inherent right of a subject of a stool or skin or member of a family to the usufructuary interest. Meaning that we have prohibited the creation of freehold possibly to strangers. But if it comes to the subject of the stool, subject of the clan, subject of the skin or family, their inherent right to be entitled to the usufructuary interest, that one has still been preserved. In other words, even though I mentioned that the case of Republic versus Regional Lands Officer Ho, ex parte is not bad law. It is only bad law in relation to creating freehold interest, possibly to strangers. But when it comes to the inherent right of a subject of a stool to acquire the usufructuary interest, that one has still been preserved under Section 9, subsection 3 of the Land Act of 2020, Act 1036. So that is the second reform that we have discussed that has been introduced by the Land Act of 2020, Act 1036. It's the reform in relation to the prohibition, in relation to the creation of freehold interest in family land. But remember that even though we have prohibited the creation of freehold interest in family land, that prohibition shall not affect the rights of a subject to acquire the usufructuary interest. To acquire the usufructuary interest. The next reform we shall look at is the restriction on the acquisition of land by non-citizens. You know, under Article 266 of the 1992 Constitution of Ghana, it reads in Clause 4 that no interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana a leasehold term for a term of more than 50 years at one time. And then other provisions of the Constitution also mention that there is a prohibition on the creation of freehold interest to non-citizens. In fact, even if you look at Section 10 of the Land Act of 2020, Act 1036, it says that a person shall not create an interest in or right over land in Ghana which vests in another person who is not a citizen of Ghana a freehold interest howsoever described. A freehold interest howsoever described. It means that when it comes to creating an interest in land to a non-citizen, you cannot under any circumstance create a freehold interest howsoever it has been described. That is Section 10 of the Land Act of 2020, Act 1036. But you notice that there are some people who are not citizens because they are aware that for a foreigner, you can't acquire a leasehold for more than 50 years at any one time. Because they are aware that as a foreigner, you can't acquire a freehold interest. These people will go ahead and just marry a Ghanaian so that once they marry a Ghanaian, then they can acquire some rights as citizens of Ghana and then use that one as a basis to now acquire a freehold or acquire a leasehold for more than 50 years. And so you're not a Ghanaian, but then you go and marry a Ghanaian, you're a foreigner, then you come and marry a Ghanaian for the sole purpose of just acquiring some rights to acquire an interest in land beyond 50 years or to acquire a freehold interest. Now, there is a restriction. The law has caught up with all of such persons. Because if you look at section 10, subsection 9 of the Land Act of 2020, Act 1036, it says that the restrictions imposed in subsections 1, 2, 3, and 7 on the interest that a person who is not a citizen of Ghana may acquire in land shall not be affected by the marriage of that person to a citizen of Ghana or by the entry of that person into a partnership with a citizen of Ghana. In other words, the restriction placed on foreigners from acquiring the freehold interest or from acquiring a leasehold beyond 50 years, that restriction shall not be affected by the marriage of the foreigner to a citizen of Ghana or by the entry of that person into a partnership with a citizen of Ghana. This is the third restriction, third reform that we are looking at that has been introduced by the Land Act of 2020 at 1036. Again, there are some foreigners who, because they are aware of the restriction that a foreigner cannot acquire a leasehold beyond 50 years, the foreigner will come to Ghana, form a company in Ghana, let the company be incorporated under the laws of Ghana for the sole purpose of just acquiring some rights. And they will say that because it's a company incorporated under the laws of Ghana, then they have a right to acquire a leasehold for 75 years, for 80 years, for 90 years. So you're a South African, you are from Benin, you are from Togo, you are from Nigeria, you are from America, you are a foreigner, and then you've come to Ghana, you are aware of the restriction that you cannot acquire an interest in land beyond 50 years. Because you know this one, you come and form a company, then you just give yourself some 51% shares, and you give a Ghanaian 49% shares, and you just use that one to come and acquire a land for 75 years. The law has caught up with you. The law has caught up with you because section 10, subsection 10 of the Land Act of 2020, at 1036, it says that for the purpose of this section, a company or body corporate is not a citizen if more than 40% of the equity shareholding or ownership is held by non-citizens. If more than 40% of the equity shareholding or ownership is held by non-citizens. If more than 40%, so if you're a foreigner, you've come to Ghana, you only want to acquire a leasehold for 75 years, so you form the company. And you, the foreigner, you have 41% shares in it. The moment you have 41% shares and you're the foreigner, that company will not be treated as a citizen of Ghana. In other words, if you're a foreigner and you come and form a body corporate in Ghana, and you, the foreigner, you have more than 40% shares, it can be 41, 42, 40.5. So long as a foreigner has more than 40% of the equity shareholding, the company will be treated as a foreign company. And therefore, once it's a foreign company, the restrictions placed will kick in. In other words, you cannot acquire a leasehold beyond 50 years. That is the answer and the reform given by the Land Act of 2020 at 1036. Then another reform that has been introduced by the Land Act is that in some places in the country, we realized that there were some people and some communities where if a woman has to go and buy land, that woman must be accompanied by a man before the woman can acquire the land. Even if the man is 10 years, 11 years, 12 years, the law in such communities are that before a woman will acquire land, the woman must be accompanied by a man to go and acquire the land. That practice is discriminatory. It's discriminatory. And so now the law has caught up with that kind of practice. And so that practice has been prohibited by Section 11. So that if you read Section 11 of Act 1036, it says that, and I quote, I'm reading in extenso from Section 11 of Act 1036. It says that a decision or practice in respect of land under customary tenure, whether the land is individually or communally held, shall be in accordance with the customs, traditions, and practices of the community concerned. But a decision or practice which discriminates on grounds of place of origin, ethnic origin, political opinions, color, gender, occupation, religious or creed, disability, or social or economic status is void. What is the lawmaker saying? The lawmaker is saying that as for customary tenure, you can hold it according to your customs. But when there's a practice which is discriminating against a person on grounds of place of origin, ethnic origin, political opinion, gender, then that practice will be void. So that if there's any community which is discriminating against women, that by virtue of their gender, they cannot acquire land by themselves and that they have to be accompanied by a man, that practice is void. That's another reform introduced by the Land Act of 2020 at 1036. Another reform that has been introduced by the Land Act, reform number 6. Another reform that has been introduced by the Land Act is that we have criminalized the activities of land guards. Land guards. So that if you look at section 12, it says that a person who unlawfully exercises or purports to exercise supervision or control of land, development in the location, and that person has no interest in land, and he extorts money or other benefits from a person who has an interest in land, or you prevent a developer from developing the land, or the person personally or through another person unlawfully uses force or violence to prevent a person who has an interest in land from having access to the land, or you drive away that person with an interest in land from the land, you commit a criminal offense. And that person is liable on summary conviction to a term of imprisonment no less than 5 years and no more than 15 years or to both. So, people who will be using brutal force to prevent owners of land from having access to their land, when you are arrested, we are told that it's a criminal offense and shall be given no less than 5 years and no more than 15 years or to both. Yes, so that is the import of section 12. And we say that it is making criminal act of landguardism, land guards, causing trouble here and there. The actions have been made criminal. Look at section 12 of the Land Act. Another reform that we shall discuss, that is the seventh reform we are discussing in this lecture, is that previously the law was that before you bring an action against a person who is developing your land, you must find a way to get a person's name, issue a writ of summons, put the person's name over there as a defendant, then you can now issue the writ of summons against that person. So that if you don't know a person's name under the old law, if you don't know a person's name, you have a land, people have encroached, they are developing, you don't know them from anywhere, you cannot sue them because you don't know who they are. Under the old law, we need to know who your defendants are. And it was very fatal to your action to bring an action and you don't name who the defendants are. But you realize they can bring a lot of injustice. Because many a time you can have a land, people may be developing a land, and while they're developing the land, you don't know them. Sometimes they even go and they develop at dawn. So you come today, you see the land. During the day, nobody is there. At dawn, they go and work. And at dawn, the building is going up. It's going up. It's going up. At dawn, then they've done 1 story. At dawn, they've done 2 stories. And you can't even tell who the people are. How do you bring an action against these people? Now, there's a reform introduced by the Land Act of 2020 at 1036. And at section 12, subsection 4, reads as follows, and I quote, a person with interest in land may make an application to court for an interlocutory injunction against a trespasser on the land, even though the name of the trespasser is unknown. Meaning that right now, we have reformed our laws, we have taken into consideration the activities of the bad people who will encroach on somebody's land and will be building, and you can't even identify who the people are. Now the act is giving us permission that we can apply for an injunction against a trespasser, even though we do not know the name of that trespasser. So on the writ and the application for injunction, you can say the trespassers. You can get it and go and post it on the land. Now the seventh reform we have looked at in this lecture. Then the eighth reform that we are discussing in this lecture, the eighth reform, is that previously, when you look at the old cases of Hansen and Ankara, Hansen and Ankara reported in 1987-88, one Ghana law report at page 639. And the case of James and Owusu, who went to the Supreme Court as Owusu and the J, reported in 1991, two Ghana law report at page 493. If you look at these cases, Hansen and Ankara, Owusu and the J, they were all to the effect that head of family, you cannot bring an action against the head of family and order him to account. Hansen and Ankara, when you read Hansen and Ankara, you will see over there that you cannot bring an action against a head of family and order him to account. And so, because of that practice, which was creating a lot of injustice, we passed an act of parliament for the sole purpose of making it possible to hold the head of family into account. An act of parliament was passed solely to bring this to stop that particular act, so that now you can bring an action against the head of family to order him to account. And that law is Head of Family Accountability Act, 1985, Penalties Law 114. This is what the act says, and I read from section 1. Despite a law to the contrary, a head of family or a person who is in possession or control of or has custody of family property is accountable for that property to the family to which he belongs, to which the property belongs. Then it says that a head of family or a person who is in possession or control of or has custody of family property shall take and file an inventory of the family property. That's section 2 of the Head of Family Accountability Act, 1985, Penalties Law 114. It says, where a head of family fails or refuses to render account or file an inventory of the family property, a member of the family to which that property belongs, or who has or claims to have a beneficial interest in the property, may apply by motion to a court for an order compelling the head of family to render accounts or file an inventory of the family property to the family. So you see that this Head of Family Accountability Act of 1985, Penalties Law 114, it was passed to cure the defects which were manifest from the case of Hansen and Ankara. Hansen and Ankara was reported in 1987-88, one Ghana law report at page 639. And that case held that as customary law, you cannot bring an action against the head of family for him to account. You have to deal with it at the family stage. And because of this, people were taking advantage. So we passed the Head of Family Accountability Act, which is now saying that you can bring an action against the head of family and order him to account. But one thing that you must bear in mind, this Head of Family Accountability Act, it is only applicable to head of family. If you look at the word over there, head of family is accountable. Head of family, head of family. It didn't say anything about stools. It didn't say anything about stools. And so, the position of the law was that now for heads of family, we can bring an action against them to account. Now, when it came to stools, there was no law that had been passed that will make occupants of stool liable to account. So the law as it stood was that as for heads of family, you can bring an action against them for them to account. But for stools, if you read the case of Owusu and the J, 1991, 2 Ghana Law Report, page 493, there was no definite statement that was made to extend the applicability of the Head of Family Accountability Act to stools. So the customary law as it prevailed before the coming into force of this Land Act of 2020 Act 1036 was that for occupants of stool, we cannot bring an action against them to account. And that the act, the Head of Family Accountability Act, only applies to heads of family. But now, if you look at the Land Act of 2020, Act 1036, we have now reformed the law so that now chiefs are accountable. You can bring an action against a chief now to honor the chief to account. And you will see this under Section 13, Subsection 2 of the Land Act of 2020, Act 1036. What does it say? Section 13, Subsection 2 reads as follows, and I quote: a chief, tendana, clan head, family head, or any other authority in charge of the management of stool or skin or clan or family land is a fiduciary charged with the obligation to discharge the management function for the benefit of the stool or skin or clan or family concerned, and is accountable as a fiduciary. Again, a chief. So you've seen the mentioned chief. A chief, tindana, clan head, family head, or any other authority in charge of the management of stool or skin or clan or family land is a fiduciary charged with the obligation to discharge the management function for the benefit of the stool or skin or clan or family concerned, and is accountable as a fiduciary. Meaning that right now, Section 13, Subsection 2 of the Land Act of 2020, Act 1036, is saying that the chief is accountable as a fiduciary. And it goes ahead to say as follows, under the clause 5, that the provisions of the Head of Family Accountability Act of 1985 shall apply to this act with the necessary modifications. Meaning that now, under the act, we have mentioned in section 13 that the chief is accountable. And in fact, it even makes it a criminal offense. If you look at section 13, subsection 4, it says that a fiduciary under this section who contravenes subsection 2 commits an offense. So we are not joking with the accountability of a chief at all. And now they have added that the Head of Family Accountability Act shall apply to that act with the necessary modifications. So the reform in this case is that when we were in the days of Hansen and Ankara, Owusu and the J, in that era, we knew that actions could not be brought against chiefs to order them to account. But now, under section 13 of the Land Act, a chief is accountable. A chief must also file an inventory. The chief too must be transparent, open, fair, and impartial. And when a chief contravenes the section, it's a criminal offense. We are bringing accountability to the stool. So this is a reform because it reforms and improves upon what we had in Owusu and the J. That is why it's a reform. This is the 8th reform we have discussed in this lecture. But read section 13, subsection 5 and 6 to show the conditions a person must satisfy before he can bring an action against a chief and order him to account. Because if you look at section 13, subsection 6, it says that despite subsection 5, a person shall not bring an action under section 2 against the occupant of the of a stool or skin or against a tendana unless that person A has first exhausted the established customary procedure for making the occupant of the stool or the skin or the tendana render accounts or maintain records of the stool, skin or plant where a procedure exists. It means that even though we are saying chiefs can account, we don't want you to just run to the court and say you have sued the chief for him to account. The law is saying that before you come, you must first exhaust the established customary procedure, which has been established and is there for making the occupant of the stool to account. To render, you must first exhaust that one. Number two, you must show that you, the plaintiff bringing the action, you are qualified under the relevant customary law to bring an action against the occupant. Section 13, subsection 6 is there. It says that the person must be qualified under the relevant customary law to bring an action against the occupant of the stool or skin or plant, as the case may be. And then the third requirement you must prove is that you must prove that you, the applicant, you are a subject of the stool or skin or member of a clan of which the chief or tendana or clan head is the administrator of the stool or skin land and has been granted leave by court upon proof that the person qualified to institute the action failed to take action within 30 days after being informed of the decision to take the action. So read section 13, subsection 6 of the Land Act, so that you can see the conditions that must be established before a person can bring an action against a chief to order him to account. In other words, even though we have said that now there's a transformation, an improvement in the law, that you can bring an action against a chief to order him to account, you can't just run to the court. You must exhaust the procedure laid out under section 13, subsection 6 of the Land Act. Then the next requirement, the next reform we shall look at is a reform that deals with the capacity of minors to enter into contracts. You know that under our general contract law of Ghana, when it comes to capacity to enter into contracts, the capacity to enter into contracts is still governed by the common law, which is 21 years. And on this, I refer you to look at the contract law textbook authored by Christine Dona Hammond, titled Law of Contract in Ghana. Look at page 69 of the book. And this is what the book says, and I quote: even though recent legislation tends to adopt 18 years as the age of majority for various purposes, there is currently no statutory provision which stipulates 18 years as the age of majority for purposes of contractual liability. The position, however, remains at the very least unclear, since there is currently no statutory provision which stipulates the age of majority for purposes of contractual liability to be 18 years. Thus, in the absence of any such statutory provision, the common law age of majority of 21 years remains applicable in Ghana. End of quote. Now let me rehash the last sentence according to Christine Dona Hammond in her book, Law of Contract in Ghana, at page 69. It says, thus, in the absence of such statutory provision, the common law age of majority of 21 years remains applicable in Ghana. What does this mean? It means that for purpose of contractual responsibility, before a person can enter into contract, the age of majority is 21 years. But because the Land Act, we don't want any problem, the Land Act has gone ahead under section 281 to define an infant to mean a person who has not attained the age of 18 years. Meaning that for purpose of land transactions, if it is only when you are below 18 years that you begin to be an infant, whereas you will not have capacity to enter into a contract. But if you are 18 years and above, by the force of section 281, of the Land Act of 2020, which pegs the age of infant to be below 18 years. Today in Ghana, if you are 18 years, because of Section 281 of the Land Act of 2020 and 1036, you have contractual capacity to enter into a transaction in relation to land. That's the 10th reform we've looked at. Now, the next reform we shall look at relates to renewal clauses in contracts and leases. You know, there is a problem people have encountered in some parts of the country. And that problem is that people end up acquiring the land, they acquire a lease for 45 years, for 50 years, and they build a mansion on the land. And then, when the lease expires, and the landowners come and they say they want the building back, you will see the tenant saying that, oh, but at the end of the day, let us renew it. Why do you want us to leave this whole 5-story building here and give it back to you? Now, the law is that when it comes to renewal process, it must be an express term of the contract. In other words, if you are buying land and you are preparing the lease, you must make sure that if you want to renew it, there must be an express provision in the agreement that will confer the right on you, the lessee, to renew it. In other words, if you go and buy the land and then there is no renewal clause, when the 50 years elapses, please pack your things and move out. You cannot compel the landowner to renew it for you. And I'll demonstrate this to you with the case of Miracle and Tete, deceased. Ire Miracle versus Tete, reported in 2011, 1 Supreme Court of Ghana law report at page 520. Listen to the words of the learned Supreme Court Justice, Edinua GSC, and listen to how she treats renewal clauses. And I'm quoting. I'll go at a very slow pace so that you get a full import of the statement. Edinua GSC says as follows, and I quote, a lease agreement is a contract for the lease of land, and thus the terms of the contract has to be by mutual agreement. Whereas some covenants by the lessor or transferor and the covenants by the lessee or transferee are implied by common law and statutes, the option for renewal is not. I'll take that portion again. Whereas some covenants by the lessor or transferor and the covenants by the lessee or transferee are implied by common law and statute, the option for renewal is not. Accordingly, the option for renewal can only be conferred on the tenant by express mutual agreement of the parties and ought to be an express term in the lease agreement. End of quote. What does this mean? It means that if you're going to buy a land at cantonment and you've acquired the lease for 35 years and there's no renewal clause, when the 35 years comes, avoid embarrassment, pack your things and move, because the renewal clause must be an express clause. That's what we saw in Ire Miracle versus Tete, reported in 2011, 1 Supreme Court of Ghana law report at page 520. But this case of Miracle versus Tete, it didn't even proceed as follows, and I quote, a lease agreement is a contract for the lease of land, and that the terms of the contract has to be by mutual agreement, that the option for renewal can only be conferred on the tenants by express mutual agreement. So if there's no express mutual agreement, then you don't have an option for renewal. Miracle versus Tete, 2011, 1 Supreme Court of Ghana law report at page 520. But because of the injustice that this can cause, that if you go around Accra, people who may end up losing their houses and they may not have any place of abode. There has been a reform that has been introduced. And this reform, you can see it under Section 50, Subsection 9 of the Land Act. But let me tell you what it says. You need to pay critical attention to these reforms. Now, the reform are in different phases. The first phase is that where land is granted by the allodial or usufructuary holder to an indigene of the area where the land is situated. Note carefully, where the land is granted by the allodial holder or the usufructuary holder to an indigene of the area where the land is situated. That one, the law says that there must be an automatic renewal. Look at Section 50, Subsection 9 of the Land Act of 2020 at 1036. It reads as follows, and I quote, where a lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest in the land, and the lessee is an indigene, and the lessee is an indigene, and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed A, the land for residential purposes, B, a farm of perennial crops on the land, or C, a commercial or industrial property on the land for the same duration as the original lease when the lease expires. So it means that today, that case of Miracle versus Tete, 2011, one Supreme Court of Ghana law report at page 520, it will be that law, it will be bad law. We have given the case a decent burial. Because now we are saying that where the lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest in the land, and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed the land for residential purposes, a farm of perennial crops on the land, or a commercial property or industrial property on the land. And the lease is supposed to be renewed for the same duration as the original lease when the lease expires. And you realize I was emphasizing on the grant from the allodial holder or from the usufructuary holder to an indigene. That is where you have the automatic renewal. Now, if you read further, there's another clause that deals with the grant in respect of leases to a citizen who is not an indigene. That one, the law treats it differently. So the first one I looked at was in relation to you acquiring the land from the holder of the allodial interest or the holder of the usufructuary interest, and you are granting it to an indigene. That's one, you have an automatic renewal. Section 50, Section 9 of the Land Act. But there's also a grant to a citizen who is not an indigene. And that one, the law treats it differently. If you look at Section 50, Section 11, this is what it says. Unless otherwise expressly provided in the lease, where bare land is leased to a citizen of Ghana who is not an indigene. Emphasis, leased to a citizen of Ghana who is not an indigene of the area where the land is situated. There shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. There shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. Now, what does this even mean? It means that first of all, it must be a lease of a bare land. Number two, it must be leased to a citizen of Ghana. Number three, that person must not be an indigene. In this case, it says that it shall be an implied term that the lease that there will be a renewal clause, that the lessee is entitled to a renewal of the lease. Now, what is very phenomenal in this portion is the opening sentence, which reads, unless otherwise expressly provided in the lease. Meaning that if you are a citizen, you are not an indigent, and you're going to acquire a land, in the document it will be put over there that you do not have a right of renewal. It means that if the parties agree and put over there that this lease shall not be renewed, the court will give effect to that one. Listen carefully, because section 50, subsection 11 says, unless otherwise expressly provided in the lease. What does this mean? It means that in the lease, the parties themselves can agree to the contrary, that they don't want any renewal. When you do that one, the court will give effect to that. But as it stands now, section 50, subsection 11, which says that there shall be an implied term that the lessee is entitled to a renewal, it shall only kick in when the agreement is silent. It means that if you are a citizen, you are not an indigent, and you want to acquire a lease, if the agreement is silent, there's no clause that deals with renewal. The law is importing a renewal clause in the lease. But remember, this applies to a person who is a citizen, is not an indigent of the area where the land is situated, and the agreement is silent on whether there's a renewal clause. So if you compare this to the first one we looked at, you realize that when it is granted by the holder of the allodial interest or the holder of the usufructuary interest, and they grant it to a lessee who is an indigent, that one, there is an automatic renewal. But if it comes to granting it to a person who is a citizen who is not an indigent, then that one is an implied term. By that implied term, the parties can agree to the contrary, because we've seen in the opening words that says that unless otherwise expressly provided in the lease. So you've seen two categories of the renewal. First one dealt with a person acquiring from the allodial holder or the usufructuary holder, and that person is an indigent. That one, automatic renewal. You've seen the other category, it's acquiring by your citizen, you are not an indigent. That one is an implied term. By this implied term, the parties can agree to the contrary. Now, let us look at the third category of renewal. The third category of renewal, that is our next reform that we are looking at, is captured under section 50, subsection 12 of the Land Act of 2020, Act 1036, and it reads as follows, and I quote, a lease of bare land, a lease of bare public land, granted by the Republic to a citizen of Ghana. A lease of bare land, a bare public land, granted by the Republic to a citizen of Ghana, is subject to automatic renewal on terms agreed upon by the parties. Meaning that this one is dealing with acquiring a lease by a citizen of Ghana from the government of Ghana, public land. That's one to automatic renewal. But take note of the caution that we are told that subsection 12 does not apply where the lease is in respect of a commercial property or the lease property is required for redevelopment. Then that's one, the automatic renewal will not kick in. So take note of section 50, subsection 12 of the Land Act of 2020, Act 1036. Then, let us look at some interesting provisions so far. But before we look at the provisions, remember the different categories of renewals we looked at. First one is relation to acquiring land from the allodial holder or the usufructuary holder and acquiring it to an indigent. That's one, automatic renewal. Second category was acquiring the land to a citizen of Ghana who is not an indigent. That one is an implied term that there can be renewal, and that one the parties can agree to the contrary. And remember the next one, lease of a bare public land. granted by the Republic of Ghana to a citizen, this one, automatic renewal. But it doesn't apply where the lease is in respect of a commercial property or the lease property is required for redevelopment. Now, let us look at some provisions about this whole renewal. Look at section 50, subsection 14 of the Land Act. This is what it says. Because this provision is important because somebody will be wondering that if you are renewing, how are we going to determine the new rent? Because I leased the property in, let's say, 2010, now 2070. How do we determine new rent if you are saying there should be a renewal? What will happen if there's a disagreement about the new rent? How do we deal with it? The law has an answer for all of you. Look at section 50, subsection 14 of the Land Act of 2020 at 1036. It reads as follows, and I quote: the renewal in subsection 7, 9, 11, and 12 are subject to the original terms of the lease, and any new terms agreed upon by the parties to the lease or their successors, agents, or assignees, taking into consideration any improvement on the land by the lessee. Then section 50, subsection 15 reads as follows: where the parties fail to agree on terms for the renewal of the lease, the dispute may be resolved under the Alternative Dispute Resolution Act of 2010, Act 798. That's a very important provision. If after 70 years they are renegotiating and we cannot agree on the amount of money you are going to charge for the place, it may be resolved under the Alternative Dispute Resolution Act, which is very important because over there, when you go, we are not going to waste time. ADR is very fast as compared to court. But if you are the parties and you fail to take advantage of the ADR mechanism, the answer is there for you under section 50 of section 16. It says that if the parties fail to resolve the dispute under subsection 15, the parties may settle the dispute in court. You see? So, if the time comes and we can't agree on the renewal, how much I'm going to pay, the law says that we may resort to ADR. But if we don't take advantage of the ADR, then we may resolve the dispute in court. You remember when I was giving you the different categories of the renewal, we looked at the renewal in respect of the lease by an indigent. We look at one by a non-indigent, and the one in respect of a citizen of a public land. Look at section 50, subsection 17. It deals with Ghanaian, non-Ghanaians. It says, subject to subsection 6 of section 10. A lease for a fixed term granted by a Ghanaian to a non-Ghanaian is not subject to renewal unless the lease expressly provides otherwise. So if you are not a Ghanaian and you've acquired a land, the law is saying that there is no implied term that there's going to be a renewal. That lease is not subject to a renewal unless the lease expressly provides otherwise. Meaning that the parties still have the chance to agree that they are a foreigner, acquired a lease for 30 years, but it can be renewed for an extra 30 years or 40 years. So they say that a lease for a fixed term granted by a Ghanaian to a non-Ghanaian is not subject to renewal unless the lease expressly provides otherwise. So let us say that the agreement between a Ghanaian and a foreigner has a renewal clause. That one, it will apply. But if there's no renewal clause, then please, then there's no renewal clause. You cannot force the person to renew for you. So look at section 50, section 18. It says that where a non-Ghanaian exercises an option to renew a lease, the renewal is subject to the agreed terms upon by the parties. When a non-Ghanaian exercises an option to renew a lease, the renewal is subject to the terms agreed upon by the parties. Next reform we shall look at, reform number 14 in this lecture. The next reform we shall look at is in relation to joint ownership of properties acquired by a spouse during the period of marriage for valuable consideration. You know, under the New Lands Act, when a party is married, the law says that if you are married and then you go and acquire a property for valuable consideration, and you acquire that property during the course of marriage, jointly acquired during the course of marriage, then the spouses shall be deemed to be parties to the conveyance. Look at section 38, subsection 3 of the Land Act of 2020 as 2026. It says, in a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the parties shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. You know, this provision here is supposed to be reflecting the ratio decidendi in those cases of Mensa and Mensa, Finn and Finn, Quasin and Quasin, Margaret J and Peter J. It is supposed to deal with those cases, because if you've read those cases, you realize that the jurisprudence of the Supreme Court, there are some cases to the effect that when parties are married and property is acquired during the pendency of the marriage, there can be a presumption that the property is supposed to be a jointly acquired property to belong to both spouses. And you see, that is why now the law is saying that if a party is married and then he is acquiring land for valuable consideration, then the spouses, the husband and the wife, shall be deemed to be the parties to the conveyance. There will be more interesting provisions we'll see about this. Look at section 38, subsection 4 of that 1036. It says, where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in trust for the spouses, unless a contrary intention is expressed in the conveyance. Look at that. So that if you think that as for you, you are a married man, you are going to buy a land, you don't involve your wife, the law is saying that where contrary to that one, the conveyance is made to only one spouse, you the spouse who wins, you shall be presumed to be holding the land in trust for the spouse, unless a contrary intention is expressed in the conveyance. There's more to this, and we'll see more. Now, because the law says that properties acquired during the pendency of marriage belong to both people, there's now a restriction on how you can even transfer it. Look at section 47 of the Land Act of 2020 and 2036. It says that except as otherwise provided in section 3 and 4 of section 38, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right, or interest in land acquired for valuable consideration during marriage, sell, exchange, transfer, mortgage, or lease the land, right, or interest in the land, enter into a contract for the sale, exchange, transfer, mortgage, or lease of the land, right, or interest in the land, give away the land, right, or interest in the land inter vivos, or enter into any other transaction in relation to the land, right, or interest in the land without the written consent of the other spouse, which consent shall not be unreasonably withheld. What does this mean? This is flowing from the section 38 that says that if you acquire land during the pendency of the marriage, then it means that both spouses shall be deemed to be parties to the conveyance. And that if one person alone goes to buy it and refuses to involve the other party to sign, then the person who goes to buy it will be deemed to be holding it in trust for the other spouse. Now, because you're holding it in trust, the law is saying that before you sell, before you enter into a contract for sale, then you must make sure that you have sought the written consent of the other spouse. And I think I can understand why this law is over there. There are a number of times in courts where you will see that a man wants a loan, and the matrimonial home, the man has used the property to go and acquire a loan on the blind side of the spouse, or a spouse has used a property to go and acquire a loan on the blind side of the husband. And then when the person fails to pay the amount on the mortgage, then the bank then decides to come here and then say that they are coming to foreclose the property and then take over the property. And that's the first time the woman may hear, or the other spouse may hear, that the property has been mortgaged. And there are times when now the spouse will now have to be kicked out, they pack everything outside. Meanwhile, that was a property that was acquired during the pendency of the marriage. It means that if that spouse would have even applied for a divorce in a lifetime, if you go according to what we saw in Mensa, quartile and quartile, and fin, if you go according to the ratio in those cases, it is possible that if she had gone for a divorce, she may have been entitled to a share in the property. So if that is the case, why is it that you were able to go and take a loan for your political ambition? You go and take a loan for some other purpose, and you didn't take the written consent of the spouse. And now the spouse has to bear the brunt of having to look for another place. So now they are saying that because the properties acquired during the course of marriage are supposed to belong to both people, properties jointly acquired, then we are saying that before you alienate any of the properties, you must take the written consent of the other spouse. And that consent shall not be unreasonably withheld. But let me draw your attention to something, because if you look at section 38, there's a way around. It says that it must be a conveyance for valuable consideration of an interest in land that is jointly acquired during marriage. Acquired for valuable consideration. It means that if you are going to buy the land, that one is for valuable consideration, so the other spouse must be a party to the transaction. But if it's a gift that is being given to you, that one is not for valuable consideration. So the other spouse cannot say he's the joint owner of the property. If it's an inheritance, the other spouse cannot claim to be a joint owner of the property, because section 38 only applies in relation to conveyance for valuable consideration. So take note of that. So we've seen Reform 14 that says that properties acquired jointly during the marriage, both spouses must be deemed to be parties to the conveyance. We've seen over there that if only one spouse goes ahead to acquire it, he shall be deemed to be holding it in trust for the other spouse. And we've seen that if a spouse wants to transfer, he cannot transfer unless he seeks the written consent of the other spouse, and that consent shall not be unreasonably withheld. Now, next thing we shall look at is the registration of lands that are also acquired for valuable consideration during the course of marriage. How do you register land that has been acquired for valuable consideration during marriage? Look at section 97, section 4 of the Act. It reads as follows, and I quote: an application for registration of land or interest in land jointly acquired for valuable consideration during marriage shall state the spouses in the marriage as the applicants, unless a contrary intention expressed in the conveyance. If you're a married person and the property was acquired jointly during the course of the marriage, they acquired that property in the course of the marriage for valuable consideration. Remember, they are saying that then the registration must state both spouses as the applicant for the registration, unless you have a different intention in the conveyance. And look at the 97, 2005, where one person will go alone and go and just write his name. It says that where only one of the spouses is stated as the applicant, the spouse shall be presumed to have applied on behalf of that spouse and the other spouse, unless a contrary intention is expressed in the conveyance. So if you alone go and you want to go and register, the law is saying that you'll be deemed to have applied on behalf of the other spouse. unless a contrary intention is expressed in the conveyance. What can be the contrary intention? It may be that in that agreement, your spouse signed that this one, you are the one acquiring a loan, that is not a part of it. But if you don't have any such contrary intention, then please, if you acquire land during the course of the marriage for vulnerable consideration, then the law says that both parties shall be the signatories. If you go and do it alone, you shall be deemed to be holding it in trust for the other spouse. And if you are going to apply to be registered, they are supposed to ask you, are you married? If you say yes, the other spouse's name must be there. If you alone, you can put your name there. The law says that you are presumed to be holding it on behalf of the other spouse. Look at 1997 of the Land Act. It is there. This is another reform. Reform number 15 that we've discussed so far. Then, look at section 125 as well. Still about this spousal issue. 125, section 1. It says that the land registrar shall, on registration of a person as proprietor of land or holder of an interest in land, issue a land certificate to the person. Then the interesting one that I like so much is the 125, section 6, and the section 7. It says as follows, and I read: where a certificate in respect of land or an interest in land is acquired for vulnerable consideration during marriage, the certificate shall bear the names of the spouses in that marriage. You see, if the land, before the registrar issues the certificate, he must ask you, are you married? Then it must bear the names of the spouses of that marriage. Then we have section 125, section 7 that deals with, and I read as follows: where only one spouse is stated in the certificate as the proprietor of land or an interest in land referred to in section 6, that spouse shall be presumed to be holding the land or interest on behalf of that spouse and in trust for the other spouse. So if you go and register alone your name, the law has caught you. It's saying that you be deemed to be holding it on your behalf and on behalf of the other spouse. Then reform number 16. It deals with a reform done to compulsory acquisition. You know, in previous times, the state is able to compulsory acquire land, and it takes a very long time before they pay compensation. Now that has been changed. If you look at section 238 of the Act 1036, it makes it a requirement that right now, before you compulsory acquire, the funds must be ready. The funds for the compensation must be ready. We don't want any trouble to now be chasing you for the money. So look at section 238 of the Land Act of 2020, Act 1036. It reads as follows, and I quote, subsection 1. Compulsory acquisition of land shall not be undertaken or facilitated by the Lands Commission unless the intended user of the acquired land proves in writing to the satisfaction of the Commission that the funds for the payment of compensation and other costs associated with the acquisition have been paid into an interest-yielding escrow account. You see, if you want to acquire land, why should you come and acquire the land for a multi-million-dollar project when you don't have the money to compensate the people who own the land? Now we have changed that. It's saying that compulsory acquisition of land shall not be undertaken or facilitated by the Lands Commission unless the intended user of the acquired land proves in writing to the satisfaction of the Commission that the funds for the payment of compensation and other costs have been paid into an interest-yielding escrow account. That's also very important. Interest-yielding. So that by the time, for example, if people are fighting over who the land belongs to, by the time they litigate and come, the funds you paid into the account, it would have accrued interest. So whoever the funds belong to, they can come for it. Who shall manage the escrow account? Section 238, section 4 has the answer. It says, the escrow account shall be managed by the Lands Commission in trust for the intended user. So this is another reform introduced by the Land Act of 2020 at 1036. That from compulsory acquisition, before you shall undertake it, please, the funds must be ready. We don't want to now come and chase you for the money. Then we have the next reform is under section 17 that says that right now we cannot have any form of adverse possession in relation to public lands. When you read the case of Memuna Moody versus Kofi Entry, Memuna Moody versus Kofi Entry reported in 2003-2004 Supreme Court of Ghana law reports. It has an interesting provision over there. You know, this case came about because of section 30, subsection 1 of the Limitation Act of 1972, NRC 54. If you read section 30, subsection 1 of the Limitation Act, it says that the act applies to proceedings by or against the Republic, as if the Republic were a private individual. The act applies against the Republic as if the Republic were a private individual. What does that mean? It means that if you look at section 10 of the Limitation Act, section 10 of the Limitation Act says that if you have a land and then you don't bring an action within 12 years, when any person has been in adverse possession on the land, then your rights over the land will be extinguished. Look at what it says. That section 1. A person shall not bring an action to recover a land after the expiration of 12 years from the date on which the right of action accrued to the person bringing it, or if it first accrued to a person through whom the first mentioned person claims. Again, a person shall not bring an action to recover a land after the expiration of 12 years from the date on which the right of action accrued to the person bringing it, or if it first accrued to a person through whom the first mentioned person claims to that person. There's section 6. It says, on the expiration of this period fixed by the Act for a person to bring an action, the title of that person to the land is extinguished. I won't delve much into this because we have a full lecture on it available on the Digital Law Village channel on YouTube, where you see a full lecture on adverse possession. So I'll just highlight on what is necessary to drum home the point about the reform. So remember that in order to get all notifications for the channel, you have to subscribe to the channel so that you can see all the different lectures that have been given in relation to land law and other courses in relation to law in Ghana. Let's come back to section 10. After you subscribe, look at section 10 again. Section 10 says that on the expiration of the period fixed by the Act for a person to bring an action to recover land, the title of that person to the land is extinguished. Meaning that if I am on your land for 12 years as an adverse possessor, and then you don't bring an action within 12 years to take over the land, my adverse possession will extinguish your ownership on the land and me, the adverse possessor, I'll be the new owner of the land, and you can't do anything about it. The adverse possession operates to also extinguish the right of the previous owner of the land. Now, if you look at the case of Memuna Moody versus Entry, it says that in relation to state lands, because section 30 says that the Limitation Act shall apply against the Republic as if it was individual, it means that if you also encroach and exercise adverse possession on state land, your adverse possession can have the effect of extinguishing the state title, and you will be the adverse possessor. That's what Memuna Moody says. Listen to what Memuna Moody says, and I quote. Section 30, subsection 1 of the Limitation Decree, 1972, NRC 54, provides that the decree is to apply to proceedings by or against the Republic as if it were a private individual. Thus, the concept of adverse possession may be applied against the state in relation to compulsorily acquired land if the necessary factual preconditions are established. So what are we being told in Memuna Moody and Entry? That right now, as at the time, that the Limitation Act that gives adverse possessors rights, it also applies in relation to compulsory acquired lands. So that if an adverse possessor and you go onto a state land and you exercise adverse possession for over 12 years, and the state doesn't bring any action, you will be deemed to have extinguished the state interest in the land, and you'll be deemed to be the owner. This has now been changed. It has been changed. Now, if you look at section 236 of the Land Act of 2020, it says that a person shall not acquire by prescription or adverse possession an estate or interest in public land. And it says that despite the provisions of the Limitation Act and any other law, a person who unlawfully occupies public land does not acquire an interest in or rights over the land by reason of the occupation. Again, despite the provisions of the Limitation Act and any other law, a person who unlawfully occupies public land does not acquire an interest in or rights over that land by reason of the occupation. This section 236 has the effect of amending the section 30, section 1 of the Limitation Act. Because you remember, section 30 says that the act shall apply against the republic as if it's for a private individual. But now we are being told in section 236 that despite the provisions of the Limitation Act, a person who unlawfully occupies public land, you do not acquire an interest in that land by reason of the occupation. And it goes on to say that a person shall also not acquire by prescription or adverse possession an estate or interest in public land. So now we have cancelled the possibility of acquiring state land by adverse possession. We have cancelled the possibility of you extinguishing a state title by adverse possession. That's section 236 of Act 1036. Next reform, that we have also criminalized unlawful occupation of public lands. So now we've not only said that you cannot acquire public land by adverse possession. Now we are saying that if you go and then you go and occupy or you encroach on public land, you've committed an offense. So we are discouraging encroachment on public lands. That's under section 236, that's section 4. Reform number 18, that a person who, without reasonable excuse, the proof of it lies on that person, occupies or in any manner encroaches on or interferes with public land, you commit an offense. And you are liable on summary conviction to a fine not less than 1,000 penalty units and not more than 2,000 penalty units, or to a term of imprisonment not less than 1 year and no more than 3 years, or to both. So you see, we've not only abolished the possibility of adversely acquiring state land, we've also made it criminal. We've also made it criminal for you to encroach on the state land. This is reform number 18. Then reform number 19, it deals with the multiple grants of land that, under the old Land Act, where we had the Land Registry Act, we had a provision over there. And in order to let you see the full import of this enhanced criminal sanction, I'll read the old act before I come to the new one so that you can appreciate the advancement. Now, section 34 of the Land Registry Act of 1962, Act 1 to 2, remember it has now been repealed. It reads as follows, and I quote, a person who knowingly, A, purpose to make a grant of a piece of land to which that person does not have title, or purpose to make a grant of a piece of land without authority, or makes conflicting grants in respect of the same piece of land to more than one person, you commit a second-degree felony and you're liable, in addition to any other punishment that may be imposed, to an amount of money equivalent to twice the value of the aggregate consideration received by that person. Now, we want to discourage people who engage in multiple sales of land and people who sell land without having any title to it. So look at section 277, subsection 2 of the Land Act of 2020, Act 1036. It reads as follows, and I quote, a person who, purpose to make a grant of land to which that person has no title, or the person who purposes to make a grant of land without authority, or a person who makes conflicting grants in respect of the same piece of land to more than one person, that person commits an offense and is liable on summary conviction to a fine of not less than 7,500 penalty units. A fine of not less than 7,500 penalty units. Now, for those of you who are aware already, as of today, that is as at date in 2022 September, a penalty unit is 1,200, is 12 Ghana cedis. A penalty unit is 12 Ghana cedis. It means that if they say conviction of not less than 7,500 penalty units, so 12 times 7,500 is 90,000 cedis. Yes. So a fine of not less than 7,500 penalty units and no more than 15,000 penalty units, or to a term of imprisonment of not less than 7 years and no more than 15 years or both. So now, if you make conflicting grants, your fine is not less than 7,500 penalty units. So 7,500 times 12, 90,000 Ghana cedis. That will be your fine. Or you are talking about term of imprisonment not less than 7 years. We want to discourage people who engage in multiple grants. So that is the effect of Section 277, Section 2. It deals with enhanced criminal sanctions for people who engage in multiple grants and people who do not have title. Like a severe punishment. So that is also a reform that has been introduced by the Land Act of 2020 at 1036. The next reform, it deals with the preparation of conveyances. Now, when you look at Section 33 of the Land Act, it says that conveyances should only be prepared by lawyers. So, Section 33 says that a conveyance shall only be prepared by a legal practitioner in terms of the Legal Profession Act 1960 Act 32. Meaning that if you're not a licensed legal practitioner in Ghana, you can't prepare a conveyance. So the surveyors, artisans, architects, they cannot prepare a conveyance. Before the conveyance will be deemed to be a valid conveyance, it must be prepared by a legal practitioner. Section 33 of the Land Act of 2020 and 1036. Then reform number 21. It deals with co-owners. You know co-owners. Once again, if you listen to our full lecture, we have a full lecture on the Digital Law Village channel on YouTube that deals with co-ownership. So you subscribe, have access to the videos, and you will see co-ownership. So co-ownership, we've dealt with already with joint tenancy, tenancy in common. We've dealt with the case of Fenuku and John Tay, and what goes into co-ownership, tenancy in common and joint tenancy. They are all there. They are all there. Now, if you are a co-owner of land, let's say you are a tenant in common, so 3 of you are tenants in common and you own land, the law is now saying that when the certificate is being issued, each of you, the owners, 3 of you or 4 of you, each of you should be given a certificate, an original certificate. In other words, we will not go and give one person one certificate for them to run a photocopy. No. We are all joint proprietors, and so we should be given, each of us should be given a certificate. Look at Section 125, Subsection 4 of the Land Act of 2020 and 1036. It reads as follows, and I quote, where 2 or more persons are registered as joint proprietors in common of the same land or interest in land, each proprietor shall be issued with a certificate. Each proprietor shall be issued with a certificate. It means that now, if there are 5 co-owners, tenants in common, each of them should be given an original certificate. Don't give one person one for them to go and run the photocopy. We won't accept it. It will be contrary to Section 125, Subsection 4 of Act 1036. So 125, Subsection 4 says that where 2 or more persons are registered as joint proprietors in common of the same land or interest in land, its proprietor shall be issued with a certificate. And then look at 125, section 5. It says that a certificate issued under section 4 shall indicate the proportions of interest of the proprietors and whether the proprietors hold as joint tenants or tenants in common. So that is reform number 21. That today, when it comes to co-ownership, each person's interest must be respected, and you have to give each person an original certificate. Then reform number 22, it deals with priority of registered instruments. Priority of registered instruments. Priority of registered instruments. Now, what does this say? If you refer to the old laws, the old cases of intem and inquanda, intem and inquanda, Jam versus Owu, Odamite and Kroku, Amuzu and Okleka. These cases were decided under the old act, that is the Land Registry Act of 1962. Now, under that act, it deals with registration of deeds. And the focus was on the time a person applies. So that under that act, if a person applies and is registered, the registration takes effect from the date of registration. So under the old law, that is the Land Registry Act, which has now been repealed, if I submit my land documents to the Lands Commission today, and then I'm unable to see anybody there to expedite my registration, and I brought it there on 1st January 2022, if you bring yours on 31st December, and you can work your way out, and then you get a document in January, even though you brought yours late, yours will take precedence over mine that was brought earlier. And that was creating a lot of problems. So in the case of intem and aquanda, the court tried to develop something called constructive registration, which essentially means that they were trying to develop a concept whereby even though a person may have brought his documents early, they will prevent that person from being cheated by somebody who brings the document late. So if you read intent and account, this is what Apollo CJ said. And I quote, Apollo CJ said that the question is what position resulted from the refusal of the lands registrar to register the documents. As I said before, the lands registrar has no power to refuse to register the plaintiff's documents on the ground ascribed to him, namely that the plaintiff's vendor was not gazetted. I do not consider the fact that the plaintiff did not institute proceedings to compel the public officer to perform his statutory duty to constrain us to hold that her title is valid. Registration of a deed under Act 122 does not constitute state guaranteed title. As the deed was stamped, it was admissible in evidence in proof of title, and that title was adjudged, registration aside, to be good. I think the only way in which justice can be done as between these parties is to hold that the plaintiff's title was constructively registered. Because equity regards as done that which ought to be done. What does Apalu say over here? He's saying that if I submit my document for registration and then you delay in the registration, there should be no reason why me, the one who bought my document early, I should be penalized. And rather, somebody who bought the document later should be given precedence. So Apalu said that I think the only way justice can be done as between these parties is to hold that the plaintiff's title was constructively registered, because he was trying to bring justice, because the law under the Act 122 was saying that we will construe it from the date of registration. Apalu says that is a bad law, and Apalu says that he has developed what we call constructive registration in order to bring justice and fairness. But Apalu was overruled. Apalu was overruled in the case of Odamte and Kroku, reported in 1989-90 One Ghana Law Report at page 14, because what Apalu did was contrary to the statutes. Statute has not given you permission. Why are you changing the law? So the holding in Tem and in Kwanda was overruled in Odamete and Kroku, where they held that there was nothing like constructive registration. And this is what Taylor Jersey said in criticizing Apalu. And I quote, and I'm quoting from Odamte and Kroku, reported in 1989-90 One Ghana Law Report at page 14, per Taylor GAC. I think the clear path indicated by case law on the tradition of third decisis principle is that the doctrine of constructive registration hinted at in Asa and Daku, and which flowered into fruition in Tem and in Kwanda, is with respect a proposition of law which conflicts with respectable case law and flies in the face of the unambiguous provision contained in section 24(1) of Act 122. It is an aberrant and erroneous doctrine. I will therefore, without hesitation, overrule the decision of Intem and Nkwanda Supra, so that it will henceforth cease to impel the Court of Appeal and the lower courts to follow it as they have done in the past. End of quote. What are we being told by Taylor DSC in Odamete and Kroku? They are saying that the provision in Act 122 is what they must go with. Because you, Apalu, that you are giving that holding, Act 122 has said clearly that registration takes effect from the date of registration. And that's what Parliament has said. So Apalu didn't have the chance and the right to go and then vary what was in the statutes. So they are overruled in Tem and in Kwanda. So that doctrine of constructive registration, where Apalu was saying that even though you have submitted the document, even though there may be no registration, he will deem that you have constructively registered it from the time you submitted it. That's holding by Apalu, even though he wanted to do justice, it has been overruled in Odamete and Kroku. But you see, Apalu wanted to do justice, but he has been overruled because the law had not changed. So now the lawmakers under the Land Act of 2020, they have gone to revisit what Apalu said in Tem and in Kwanda. So that now, if you look at section 213 of the Land Act, they have restored that voice of Apalu that was in Tem and in Kwanda. Listen to what section 213 of Act 1036 says. It said as follows, and I quote, a complete application which is submitted for registration in respect of a particular parcel of land shall have priority according to the order in which the application is presented to the registry. Emphasis, shall have priority according to the order in which the application is presented to the registry. So that now the focus is no more on when it was registered. The focus is on when it was presented to the registry. So that if I present mine today, and you bring yours 3 months' time, 4 months' time, and yours is registered earlier, even though yours is registered, it will not take precedence over mine, because 213 is saying that shall have priority according to the order in which the application was presented, not when it was registered. So we have gone ahead to prevent the days of Amuzu and Okleka, Jan and Owu, in time and in Kwanda, Odamte and Kloku. We have represented all of that, and we are seeking to prevent the injustice that can cause to people, where people submit their documents and through no fault of theirs, someone deliberately delays their registration. Now, Section 213 is stopping that. 213 says a complete application which is submitted for registration in respect of a particular parcel of land shall have priority according to the order in which the application is presented to the registry. It shall have priority according to the order in which it is what? Presented. That's another reform introduced by the Land Act of 2020 at 1036. Then also, reform number 23. Now, if you remember the case of Ninote Umabu III, Mr. Attorney General and Lands Commission, reported in 2005-2006, Supreme Court of Ghana Law Report at page 579. One of the conclusions drawn in that case, on Sumache Layout case, was that after the coming into force of the 1992 Constitution, there shall be no new vesting of stool or skin lands. That was one of the conclusions drawn in the Ninote Umabu case, the Osumanche Layout case. Now, an attempt has been made to codify that conclusion drawn in the Ninote Umabu case. So, if you look at Section 268 of the Lands Act of 2020 at 1036, the lawmaker has now totally abolished vesting of land, because we got a hint in Ninote Umabu, Mr. Attorney General, that after the coming to force of the 1992 Constitution, there shall be no new vesting of stool or skin lands. Now, the lawmaker has gone a step further to make it express. So, look at Section 268 of Land Act of 2020 at 1036. It says that on the coming into force of the 1992 Constitution, it is unlawful to vest stool or skin land in the state. After the coming into force of this act, it shall be unlawful to vest clan or family land in the state. What is the lawmaker saying? That now there's nothing like vesting stool, family, or clan land in the state. So the only one that's left is individual. But if they've made it unlawful to vest stool land, skin land, family land, it means that invariably we have come to the end of vesting of lands. So the voice we heard in Ninote Umabu, the third and Attorney General, the Osumanche Layout case, it has been given statutory blessing under Section 268 of the Land Act 2020 at 1036, that now we don't have any vesting of land in Ghana. That's the 23rd reform we have discussed in this lecture. Then the 24th reform we shall look at is a provision that used to be in an airline, that before you register a land, then the site plan must be approved by the Director of Survey and Mapping Division. Now, that provision in the airline has been given statutory blessing. So if you look at Section 208 of the Land Act, as 1036, it says, every plan shall be prepared by an official surveyor or a licensed surveyor. When a plan is prepared by an official surveyor, the plan shall be approved by the Director of Survey and Mapping Division. And a licensed surveyor, the plan shall be certified by the licensed surveyor and approved by the Director of Survey and Mapping Division. Meaning that provision we had in the airline, we have elevated it and given it a statutory force, so that right now it's in a statute that every plan must be approved by the Director of Survey and Mapping Division. That is reform number 24. Then our final reform we shall discuss for this lecture is reform number 25, which is electronic conveyancing. That the Lands Act of 2020, Act 2036, introduced provisions that deal with electronic conveyancing. So that right now, there are provisions in the law that allow us to engage in electronic conveyancing. Look at section 73, section 1. It says as follows, that where in this act a transfer of land or an interest in land is required to be made by a conveyance, that transfer is lawfully made if the transfer is by an electronic conveyance. We didn't have provisions about electronic conveyance in our laws. But now the section 73 is making this possible. That where in this act a transfer of land or an interest in land is required to be made by a conveyance, the transfer is lawfully made if transfer is done by an electronic conveyance. And so we mean that we had a new addition as far as our land laws are concerned. So we discussed 25 reforms in this lecture. 25 reforms in this lecture. So by way of recap, you should remember that we started this lecture by looking at the laws that have been repealed. We mentioned all the laws under section 2A2 that have been repealed. Remember that we went ahead to look at first reform, that is the clarity of interest in land in Ghana, under section 1 of the Lands Act, where we look at the different categories of interest: allodial, common law freehold, customary law freehold, usufructuary interest, leasehold interest, customary tenancy. We went ahead to look at the reforms in relation to the prohibition of freehold interests. And we mentioned that right now, even though we are prohibiting freehold interest in family land, there is still the right of a subject to acquire the usufruct. Remember that we dealt with another reform that was in relation to foreigners acquiring land in Ghana. That if you are a foreigner, you can't acquire a freehold and you can't acquire a leasehold beyond 50 years. And we mentioned that right now under our law, under section 10, and then if you also look at section 10 of the Lands Act now, the restriction placed on foreigners shall not be affected by the marriage of a foreigner to a citizen of Ghana. Remember, we mentioned that right now too under our laws, if you have a company where a foreigner owns more than 40% shareholding, that company shall be treated as a foreigner and shall not acquire a leasehold beyond 50 years. We dealt with the reform that related to women, that now there is the practice where some women could not buy land unless they were accompanied by a man. That discriminated practice, it has been abolished by section 11 of the Act. We look at the criminalization of the activities of land guards under section 12. We again look at the new introduction in our law that now you can bring an action against trespassers, even though you don't know their names. We saw that under section 12, section 4. Again, we saw that now under our Lands Act now, you can bring an action against a stool and order the stool to account. Remember that again, we looked at another reform in our law that related to bringing actions in relation to heads of stools, occupant of stools, that now you can bring an action against them to account. Then we look at the reform in relation to the capacity to enter into contracts in relation to land. That because the general rule is that in Ghana, the common law rule of 21 years applies for contracts, we have specified in the Lands Act that the contractual age for majority is 18 years as far as land is concerned. And we refer to section 2H1 of the Lands Act. Remember that we dealt with the reforms done on renewal process. And remember the distinction we gave for person acquiring from an allodial or usufructuary holder and it's an indigent. We do a distinction between that one and a citizen who is not an indigent. And we look at also acquiring a land from the government, public land. Remember the different categories of renewals that we look at. And then also, remember the provisions we dealt with when it comes to spousal property. That today, if you are married and you acquire property for valuable consideration in the course of the marriage, according to section 38, it shall be deemed to be property jointly acquired during marriage. there's a restriction under section 47 that you cannot transfer it without seeking the consent of the spouse. And then if you are even going to register under section 97, you must state the names of both spouses. And if only one person states the name, he'll be deemed to be holding it in trust for the other. And then remember that we also look at compulsory acquisition. That today, before you compulsory acquire land, we don't want trouble. Make sure the funds are available before you can compulsory acquire the land. Section 238 of the Act. Remember, we also mentioned that today, now, you cannot say that you have acquired a compulsory acquired land by adverse possession. That if the state has compulsory acquired land and you go and encroach, the days of Memuna Moody Pescopi entry are over. So that now you cannot say that you have acquired a state land by adverse possession. You will not even succeed it. And then we are told that it's even a criminal offense. It's a criminal offense. So you not succeed with it if you want to acquire a state land by adverse possession. Then reform number 18 that we looked at, that if you unlawfully encroach upon state land, it will be deemed to be a criminal offense. We also look at the enhanced criminal sanctions for people who engage in multiple grants of state land. And then that was under section 277, subsection 2. And then we look at the reform in relation to conveyances, that they can only be prepared by lawyers under section 33 of the Lands Act. Then we look at the rule in relation to co-owners of land, that today, if you are a co-owner of land and you register, the land register must give you all original certificates. It cannot be just one. Look at section 125, subsection 4. And then we look at the priority of registered instruments. We went over the days of in time and in quanda, Jan and Owu, Odamite and Kroku, Amuzo Nokleka. And we've seen the prevailing position now, that right now we give precedence to the time you submit a document for registration and not when it is registered. And on that, look at section 213 of the Land Act. Now, the next reform we looked at was the codification, the partial codification of Nino Teo Mabo, the third and Attorney General, where we say that now, according to section 268 of the Land Act, we do not have any vesting of lands anymore in Ghana. We don't have any vesting of lands anymore in Ghana because section 268 abolishes the vesting of stool land in the state. It abolishes the vesting of family land too in the state and clan land. So we don't have any vesting. The next reform we looked at was that site plans must be approved by the Director of Survey and Mapping Division. I mentioned that it was previously an airline, but now it has been elevated to a statutory status. And then finally, we look at electronic conveyancing. These are 25 reforms that have been introduced by the Land Act of 2020 Act 1036. And this is where we shall bring our lecture to an end. Remember that we didn't delve into details about the substantive principles because we have other lectures available on the Digital Law Village platform. And so when you subscribe and you go to the channel, you see several of the videos where you can listen to where substantive law principles on land law in Ghana have been discussed. And so, for purpose of the reforms introduced by the Lands Act 2020 Act 1036, this is where we shall bring our lecture to an end. Thank you.